Hey, what's up, guys? It's April 20th, 2020, and we have some constitutional law news to talk about. This is a con law roundup. Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today we have a little bit of a different show. It's a con law roundup. These are 3 con law stories I want to spend just a couple minutes each touching on. We're not going to go deep into every story, but they're all very important, and they all dropped here on April 20th of 2020, right in the middle of coronavirus. And they're all very important things. So if you like these legal short story news things, roundups, opinions, hot takes, all of that, please like and subscribe. Now let's get into this. So here we go. The U.S. Supreme Court finally requires unanimous jury verdicts for serious crimes. So most states already practice this, right? If you're going to go and sit for a jury of your peers because they accused you of murdering someone, you got 12 people sitting there. You want all of them to have to say you're guilty because the legal standard is beyond any reasonable doubt, right? Well, this is how it's been federally forever, and how it's been in 48 of the 50 states for a very long time. Not Louisiana, not Oregon. They've held on to this idea that you can actually have a split jury convict you. Now, does that matter so much for a parking ticket or something like that? Yes. Yes, it does. Although people aren't as worried about that. Where it really matters are serious crimes with very long sentences. Like, I don't know, murder. And that's what this comes out of. This actually comes out of a conviction in Louisiana for murder, but he was convicted by a 10-2 vote. Now, if you don't remember, our system requires that your guilt in a criminal matter be proven beyond any reasonable doubt. Well, if you have 2 people saying that you're not guilty, there's some reasonable doubt still there. That's the idea, is that if even one person says, you know, I just can't see it, I can't find this guy guilty, and the jurors are examined for competence by the 2 legal teams. The attorneys have a chance to say, we don't think this person is actually capable of making this decision, and get rid of them. So the jury pool that you get is agreed upon kind of by both parties. And so with that, we've determined that they're competent. They're not mentally ill. They're not drunk or whatever. And so they're there to actually competently, as a reasonable person, selected randomly from the populace, determine the guilt or innocence of the person. So that person presumptively can determine if there was reasonable doubt or not. And if they think that someone is not guilty, then they can't be guilty. That's how it's been, like I said, in federal crimes forever. Does that mean that someone who's otherwise guilty might go free because of one juror? Yes. Yes. And I think what's the adage? Better 1,000 guilty people go free than one innocent man be confined. It's something like that. That's the idea behind this unanimous verdict. And we finally have a Supreme Court decision overturning prior Supreme Court decisions saying, no, we actually do need unanimous jury verdicts, especially on these severe, serious crimes. I mean, the idea that you could go to prison for the rest of your life while 2 out of 12 think you're not guilty should rankle you. That should bother you at some level. Like, wait, what if I was there though? And 2 out of 12 people are like, but this guy's not guilty. And they're like, well, sorry, you can't reasonably hold that conclusion. So he's going to prison, or you're going to prison, or whatever it is. So how they did this real quick is through the 6th Amendment incorporated by the 14th Amendment. And a quick con law lesson. Prior to Reconstruction, that's the passage of the 13th, 14th, and 15th Amendments following the Civil War. Prior to Reconstruction, the Constitution, and specifically the amendments, say the Bill of Rights, for example, did not actually apply to your state and local governments. Your state and local governments were their own sovereign entities that did not have to abide by the minimum guarantee of rights that we expect today from the Bill of Rights. In theory, your state could infringe on your right to free speech or your right to own a gun, or the state could quarter a soldier, for example. These basic fundamental rights, your right to reasonable freedom from unreasonable searches and seizures, or the warrant requirements. States, now most of them didn't, but they could infringe on those rights in different ways. Once the passage of the 14th Amendment came, it ensured due process applied down through the states. Did that mean that all of the Constitution automatically, immediately applied to the states? No. There's a process called incorporation, and that's where the Supreme Court has to review a particular portion of the Constitution with regards to a state and incorporate that through the 14th Amendment to apply to the states. Now, typically they do this and it's effective and it's done. However, the idea is that there may come a time where they determine that that right doesn't apply down at the state level, hypothetically. But typically it's just a matter of getting a case involving a particular amendment or a particular thing applying to the state, where the state is violating the right that would be guaranteed under the federal Constitution, and therefore we're going to apply that minimum standard and incorporate it through the 14th Amendment and then apply that down to the state and local levels as well. We have now used the 6th Amendment, which importantly doesn't say anything about a unanimous jury verdict. It doesn't say it expressly, but we've used the 6th Amendment and your right to a jury trial, an impartial jury trial. We've used that 6th Amendment to require the unanimous convictions. And the unanimous convictions in federal court have, like I said, that's been a practice basically forever, since the founding. And the idea is that those unanimous verdicts were probably what was understood as a jury verdict by the founders when they wrote the clause, hence why they practiced it federally, right? So that's the idea. But anyway, this is a great ruling for justice. I mean, it may make some people uncomfortable to know that a guy who's been convicted of murder is now going to go free because of this. But he was only convicted by 10 of the 12 people. And if he were in any state other than Louisiana or Oregon, he would not be convicted. He would have been free. If he was federally charged, he would have been free. Any state other than those two, and the guy would not have been convicted for murder. So now his conviction is reversed, and it will abolish those state practices of allowing non-unanimous jury verdicts in serious crimes. That's a great outcome. Good job, Supreme Court, bringing justice to the people. What are these ads doing these days? How irritating. All right, next story. Next story. This is an editorial from the Washington Examiner saying to amend the Constitution to abolish recess appointments. Okay. They've got a problem. The problem is that Trump has threatened to use his presidential power to adjourn both houses, creating a recess and thereby allowing him to appoint people to what he calls critical positions inside the administration without consent of the Senate. And if he's able to do that, he can use the recess appointment power to go ahead and appoint these people through the end of the Senate's next term. So a brief overview of this. The president has the sole power of appointment of officers of the United States, right? So he gets to appoint people to positions. And in that appointment process, he needs to get advice and consent of the Senate. That means that the Senate has to approve his appointments. Now, recognizing the fact that sometimes something could happen where the Senate isn't in session and someone is dead or a vacancy opens up, someone resigns, I don't know, they get a sweet gig somewhere and they're like, peace out, government, I'm going to go work in the private sector. They go to do that. Then we might need to fill a position while the Senate's not in session. And if you think back to when the Constitution was written, if the Senate's not in session, bringing the Senate back would take weeks. You'd have to send people on horses with letters to each of the senators all across the country. They'd have to ride out. The senators would have to prepare for a long journey back to Washington, and then they would have to be there for a very long time. It was a real uprooting process, which is why they had a very long recess, several months between the two sessions that occurred in a 2-year period. That recess gave them time to go home and manage their affairs. They didn't have Skype, right? They couldn't just call up their house manager and be like, hey, make sure you crop rotate today. Right? They can't do that. So they had to have this recess appointment power. Now, what really makes the Washington Examiner salty here, it seems, is that Obama got slapped down back in 2014 because he made recess appointments. But he made recess appointments while the houses weren't in recess. Okay? So there's this adjournment rule where if the House and Senate are in session and either house wants to close for more than 3 days, the other house needs to consent, and then that could put them in some type of recess, right? And that's it's either a inter-session recess, where it's a recess between the two sessions, or it's an intra-session recess where it's a recess during the session. Long story short, in the 2014 Supreme Court decision, they made some distinctions between those things, but ultimately determined that the text of the Constitution doesn't make that big of a distinction. It's largely based on the historical practice of presidents using the recess appointment power and how short those actual recesses were. And what the Supreme Court decided was that basically, if you have a recess of less than 10 days, then you're not actually in recess as far as the appointment power is concerned for the president. Now, what happened back in 2014 is the Senate was in its recess for 3 days, but the House was not. The House, which was controlled by Republicans, was staying open with what's called a pro forma session, where they say, we're here, session's in, adjourned, because we don't have a quorum or whatever. We don't have enough people to do anything, but we are here. So we're still in session. So then while that was happening, the Senate couldn't recess for longer than their 3 days because the House was in session and wouldn't consent to it. Now, what they're saying here is that Obama could have attempted a trick. And by trick, they mean a constitutional authority vested in the president under Article 2, Section 3. But that trick says that specifically the president may, on extraordinary occasions, convene both houses or either of them, and in case of disagreement between them with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. Now, they're suggesting that in back when Obama did this, it wasn't 2014, I think it was probably 2014 when he actually did it. The Supreme Court was in 2014. I don't remember what specific year the appointments were. Doesn't matter, because they're suggesting that Obama could have adjourned the houses because it was an extraordinary occasion, but it wasn't. That's the big difference we have now between now and back then, because we have the same thing. Right? We have the same thing now. The Democrat House is in these pro forma sessions, therefore preventing the Senate from doing a full recess, which would allow the president to do appointments. Is this a political power that the House is able to do? Yes. Does it make the Democrats scumbags? No. Did it make the Republicans scumbags and they did it to Obama? No, of course not. This is part of the balance of powers between not just the executive and legislative branches, but the House and the Senate. right? They can't give, the Senate would have quite a bit of authority if the Senate could just recess itself and avoid the appointment process and let a president just do recess appointments for everything. If the Senate decided to, without the consent of the House, shut itself down, more importantly, they could prevent bills from being passed just because they have a political composition disagreement between the House and the Senate, like we do now. If the Democrats in the House want to pass bills and the Republicans in the Senate could just say, nah, peace, we're adjourning it forever, and the House has no say in it, we've got problems. So there's a balancing act going on that exists. The problem with this article, which its ultimate thesis is get rid of recess appointments because we don't need them now, I disagree. I disagree with that entirely, and so does the Supreme Court. You may need recess appointments. Here they're suggesting that Obama could have adjourned both houses and therefore made the recess appointments. But there's that pesky bit that of language in there that says may on extraordinary occasions. Obama wasn't in an extraordinary occasion. Trump might be. A virus that prevents the convening of Congress, that prevents them from congregating together to go ahead and vote on things due to social distancing and all of the people that would impact. Because it's not just the dummies that are actually elected. It's all of their staff. It's all of the aides. It's all of the food service, the drivers, everybody involved in bringing Congress together. It's a massive organism with a lot of people concentrated in a very small space. And when you've got a pandemic, you've got the potential to transmit a disease that could then kill all of the geriatrics in Congress. That would be the other problem, right? Most of these guys are kind of old, and that puts them in the high risk category for the current pandemic. All of this to say, we may have an extraordinary occasion now. We most certainly did not when Obama was doing it. A political disagreement between the House and the president is not an extraordinary occasion. An extraordinary occasion is a global pandemic which has caused states to literally shut down businesses. Something that is very, very rare. Actually, I don't think states have largely done it, even in the face of pandemic. I think it was mostly cities. If we're talking about Spanish flu and other outbreaks, it's mostly city by city. Now we have actual whole states shutting down, interstate travel being reduced, international borders being closed to a large extent, and we may have extraordinary activity now that we've never had before. That's the balancing act. And if Trump were to do it now, it would be challenged. And then that extraordinary occasions would be put into a test. What does this actually mean? Here, though, the Washington Examiner appears to be just unthinking in their editorializing and trying to use a comparison that doesn't really jive out. And that's the comparison of Obama's situation versus Trump's situation. Had Obama thought to go that extra mile, or if he did think it, had he been willing, they absolutely thought it. He was unwilling because there was no extraordinary circumstance, no extraordinary occasion going on. That's the deal here. And then what they propose is what would have happened here is it would have created a permanent loophole for unlimited recess appointments by his successors. No, that would make it an ordinary occasion. Washington Examiner. It's the plain language of the Constitution says extraordinary occasion. If it's what everyone does, it's not extraordinary. It's extraordinary. It's just ordinary. Anyway, bad constitutional read here, bad understanding of the decision that went for Obama and why, or went against Obama and why, and a really bad take, as they wrote in January 2013. The recess appointment power was intended to ensure government could function when officials died or resigned during the 6 to 9 months when Congress was typically absent each year in the early days of the Republic. This view was unanimously rejected by the court. The Supreme Court of the United States disagreed with you in January of 2013. or well, they disagreed with you in 2014 when they issued their ruling, and they disagree with you now. The recess appointment power was not intended to ensure government could function when officials died or resigned during the recess. They addressed this specifically in the decision against Obama, that it's not just those who died during the recess, it's those who had vacancies during the recess, whether they died before or after, because government moves slow, and sometimes someone dies and then the recess occurs, and then you need to fill the position. Maybe the position was non-critical when they died, but something comes up where they need a decision. They need decision makers, and they need people to act, or specialists to be brought in for a specific thing. The Supreme Court basically said, so long as the position existed prior to the recess, the president can appoint someone. What they can't do is create a new position during the recess and then appoint someone. That might be a stretch. But it says, let's see, it makes no sense today when every senator can catch the next flight to Washington to deal with any truly urgent vacancy. Oh no, it makes a lot of sense when you have a global pandemic that may prevent people from gathering in places, because it will literally put them and everyone around them and then their home states at risk of further infections. That's the whole idea we have going here. And the final one, Harvard professor, this is just kind of a comedy one. Harvard professor wants a presumptive ban on homeschooling, claims it promotes white supremacy. Yep, that's the problem that the Harvard professor has with homeschooling. Look at Ben Shapiro, looking old there, Ben. Harvard is playing host to a homeschooling summit, which I'm sure will be filled with experts on the pro-homeschooling side, slated to take place June 18th to 19th. But Harvard's concern isn't so much whether homeschooling is a viable, cost-effective, and comfortable method of education for many Americans, but rather whether homeschooling is, and homeschooling children are, a ticking time bomb. Now, this is from the Daily Wire, so it's written a little bit inflammatory. It's obviously slanted towards the right, but the idea is, of having a presumptive ban on homeschooling would be to take something that has been a constitutional right of parents, and that is to raise and direct their children's education. Has been enshrined in the Constitution basically forever, but specifically in a decision from 1925, recognizing that states can regulate the education, but they cannot regulate how that education, or they can create standards. That's the regulation, right? The state can create standards for students. What they can't do is determine specifically how and in what venue those standards will be met, right? So if parents are able to keep their children at the standard, recognizing the idea of like a standardized test or a standardized skill set, then they can do that on their own through homeschooling. That creates, in essence, a fundamental right to direct the education of your own children. And this makes sense. This makes sense. This should require a constitutional amendment, because the idea that parents are in charge of their children's education is something that would have obviously existed at the time of the founding, when there wasn't a public school system at all, and shall persist, should persist going into the future. This is why we can have private schools. This is why you can raise your children in a specific way. Heck, it's why you can take your child out of the school system to do things like travel around for some sort of job. Say, for example, your child is a recording artist and needs to bring a tutor with them to school them on the road, to make sure they're getting their education while still capitalizing on their talent and business thing. Or say parents have to move around and bounce from state to state, and it's less traumatic on a child to have a homeschooling environment than it would to bounce them between schools and different social groups and different social mores and norms that occur in these different social interactions that they're facing. There's a lot of sense to homeschooling for a lot of people, but the basic reality is that homeschooling is in America, it's a fundamental right. You have the right to direct the education of your child, and we don't get to take that away just because some pointy-headed moron from Harvard thinks that we should be able to stop homeschooling in this way. there you go, guys. That's a quick con law roundup. Hope you enjoyed this type of content. If you do, again, like and subscribe and share it with your friends. We'll see you around. Peace. Peace.